Counsel, could that possibly be because we're assuming that Congress was focused on accounts when it's possible that they were actually focused on the person? So the thing that I'm trying to get my mind around is the fact that in 5314, I don't even see the word account. It says, it refers to persons who make a transaction or maintain a relation. So first of all, we have no account word in this statute. And then when I look at the history of it, it appears to me, and you might correct me if I'm wrong, that Section 5314 originally directed the Secretary to require any resident or citizen who engages in any transaction or maintains any relationship to file this record. And when they amended the statute, they said, they changed it to the language that exists here, but said this is really not a material change. So if that's kind of how we're looking at it, then I think maybe we're not even being directed by the statute to care so much about the accounts, because what Congress was trying to do is give the Secretary information about who was engaged in these kinds of activities, and then the Secretary could go afterwards and ask them for more information. There's that provision about the 25 accounts or whatever. You don't even have to give the information. So as long as the Secretary knows who is involved in this, then they have the essential nub of information that they need to do further investigation. That's how I'm looking at it. Am I wrong?
Yeah, I don't think you are, and I actually think that the points Your Honor has made, I think, support our theory exactly. So the original version of the Act talked about who needs to file a report. It didn't say what you have to file. So Congress is not trying to say in that language. The only language, by the way, even in the old version or the current version, that even debatably references account is that maintains a relation language. That's what they're referring to for the account. But when Congress did that, they didn't say you need to report each account. They're simply telling the Secretary, by the way, Secretary, you figure this out. You figure out what rules we need. This is the regulated class. This is who you're regulating. It's not what that regulated class has to do. And when Congress
Go ahead, finish your
sentence. When Congress then premises the violation on the statute, and it's not on the regulation, so, and again, when the Secretary did make these regulations, it's very odd to think that this was an account-specific focus when they're activated by an aggregate account balance. You could have 100 accounts that's under the $10,000 in one threshold. You don't have to report anything. And for people who have lots of accounts, you don't have to report what those accounts are. So I think it shows the Secretary also understood the statute is effectively looking at money in foreign bank accounts and foreign transactions, and not necessarily focused specifically on each individual account as giving rise to a separate $10,000 violation.